All right, let's go ahead and call the meeting to order. Thursday, July 18th, 2019. Do we have, we need to adopt the agenda as it is? Do I have a motion to adopt?
I'll make a motion.
Do we have a second?
I'll second.
All those in favor signify by saying aye.
Aye.
All those opposed? Item number 3 is the approval of the meeting minutes of May 14th, 2019. Do we have a motion to approve those minutes?
I'll make a motion.
Do we have a second?
I'll second.
All those in favor signify by saying aye.
Aye.
Those opposed? Which brings us to item number 4, public hearing. At this time, I'd like to read a conflict of interest disclosure statement. On today's agenda, public hearing appeal number 1-2018, Kristie Atwood. I would like to disclose the following. I am an employee of Cline Construction, Inc., located at 86 Menifee Lane, Farmville, Virginia, 22630, who has a personal interest in a transaction as defined by the Virginia Code 2.2-3112A, pursuant to the Virginia Code 2.2-3115F. I am disclosing that I did work for Martha T. Buracker, DBA Buracker Construction, located at 3452 Bentonville Road, Bentonville, Virginia 22610, which constructed the home located at 1255 Pilgrims Way in Bentonville, Virginia, permit number 493-2015 for Kristie Atwood. That is the subject of today's appeal. The transaction has application solely to property or a business or governmental agency in which I have personal interest. Accordingly, I must disqualify myself from hearing this appeal before the local board of Building and Code Appeals. I ask that this disclosure be made part of the minutes of this meeting. And at this time, I will turn the meeting over to Jason Ham, counsel for the Building Code Appeals.
So at this point, there needs to be a temporary presiding officer, like we did last time. I understand you have a vice chair, but the building code requires you to go through that procedure. So if someone wanted to make a motion to appoint one of you to be the temporary presiding officer, that would be appropriate.
I make a motion that we make Art Sabell the presiding officer.
I'll second.
We need to do a vote.
Is there, all those in favor? Say aye.
Aye.
Parliamentary inquiry, acting chairman.
Yes.
Pursuant to the bylaws, Article 1, Section 1.4, at sequence, what authority does the board have for such action just taken?
To appoint me as chairman.
Yes.
I can read you from the handout that was provided to me, guidelines on conducting the meeting. It's on page, just a second, let me get to that page. Election of a chairman. It's on page 5 of the guidelines that were handed to me when I asked for the guidelines to conduct the meeting. It says, while the appeal provisions are silent on the election of a vice chairman, it would not be prohibited if a vice chairman is elected, then a vice chairman would serve as chairman in chairman's absence.
So, as I read Article 1, Section 1.4 of the bylaws, and the records of the Board of Building Appeals have no, when I checked, have no record of adoption of any other guidelines other than the bylaws, which would have to be done by the county. It says the vice chairman shall assume the duties of the chairman in the chairman's absence, disability, or disqualification. It's my understanding you're not the vice chairman.
I am the vice chairman.
You are the vice chairman?
Yes.
All right, I withdraw my parliamentary inquiry.
And if there's any questions into when I became vice chairman, it was at the November meeting. I don't have the date right off the top of my head, but I was elected to the board. The board took a vote on replacing officers, and at that time is when I was elected.
Very well. Thank you.
All right, yes, I would like, before we start these proceedings, I would like to address a couple things. Mr. Tyler, at our last meeting, when we granted you guys continuance, you was on the phone, we asked you, if you could give us a timeline on how long you thought this meeting would take, and you said roughly between an hour and a half to 2 hours.
Correct.
Okay, I'm going to kind of direct the board and hold you to that guideline today. We do want to try to hear and complete the issues as best as possible. In regards to the jurisdictional issues that I asked at the last meeting, I asked that all persons present submit their entries cut off of the end of the business day on June 14th. The only ones we have received at this point are from Mr. Francis. Just making sure nobody else submitted any present to June 14th.
Your Honor, I apologize, Mr. Chairman.
Yeah.
The Burackers, or Buracker Construction LLC, I don't believe has standing
Mr. South, all I'm doing is asking you if you presented any issues prior to that date.
No, we stand on the basis of the appeal and the referral back from the State Technical Board.
Okay.
That being said, I think it's an ultra-virus act to invite non-parties to the proceeding. And according to the state code provisions regarding this, who is an entity to this proceeding, it's only my client and the building code official, no other party.
Respectfully, I disagree. The building code 119.7 says any persons whose interested are affected by the building official's decision in question shall be given an opportunity to be heard. Here we are. Thank you.
May it please the chairman and the members, the third party referenced would be the property owner or builder, not the contractor. I would refer you to the handout from the Virginia Department of Housing Community Development Office of the Review Board, which has promulgated the regs. Many of the specific requirements contained in the USPC and FFPC, and I'll be frank, I don't know what the SFPC is. In addition to procedures may be established by the bylaws of the board and others are standard practice for all quasi-judicial boards, of which this is. Typically, there are two parties involved, the appealing party and the enforcement official. The third party, in this case, in the reference code section, we contend would be the property owner. Typically, it's a contractor appealing this, not the property owner. I submit that for your consideration.
Okay, Mr. South, if we want to go that route, then we need to make sure that you understand that all third parties, we have to represent that with all third parties. The building official, if we're going with the building official is the one that makes the determination, and they have to submit in writing to the building official a request to be a third party for inspection purposes. So you're the way I'm looking at it, Mr. Ham, tell me if I'm wrong, but then based on what you're saying is the home inspection that you did was not a third party.
First of all, you're now assuming facts not yet presented to this board for this hearing, to which I must make an objection.
Third party thing up.
He's not a party, he's a witness. That's entirely different.
All right, Mr. Sarli, you've made your point clear, and Mr. Chairman, I think it'd probably be good to go ahead and move forward with the merits of this, or any consideration of the jurisdictional issue that was raised by the Burackers.
Okay, so let's go ahead and get this. Your comment is noted.
Thank you.
So let's go ahead with the. Hold on just a second. I got. Give you my notes over here. Okay. All right. I'm gonna let Mr. Solid, if you have an opening statement, let you start.
Do you request that I use the podium or stand here at council table?
Excuse me?
What is your preference, that I use the podium or stand at council table?
Can everybody at the board hearing from the table? You can stay there.
Green lights on. Could everyone hear me, or is it better there, on that end of the dais?
Okay.
Okay. Good afternoon. I'm having a sense of deja vu, and many of you all are as well. And we're having that sense of deja vu because certain people, which is endemic to this entire case, don't like to follow the law. A member of this board, and it was contested at the last hearing. I remember arguing about conflict of interest before you all chose to stay a part of the tribunal. And now we have an official opinion that there was a conflict. That's part and parcel of everything that my client has been a victim of. And let that sink in for a moment. She is a victim. She's a victim of a contractor engaging in contracting practices, entering into contracts requiring a contractor's license when none existed. At the very beginning of this case, that man never should have caused a building permit to be issued. Buracker Construction LLC was the contractor. They did not have a contractor's license. My client requested a meeting before the Warren County Board of Building Appeals regarding construction issues at her home located at 1255 Pilgrims Way, Bentonville, Virginia. A bit of background. On March 16, 2015, her family experienced a horrific event, something no one in this room ever wants to experience. The loss of nearly everything you own. Her home burned up. Yes, Mr. Ham, your smirk is noted.
I am not smirking, Mr.
Yes, you are.
And, you know, if you want to spend your
Her
time
family
insulting
experienced a
me,
horrific house fire and forced to rebuild their home from the ground up. She made the unfortunate mistake of hiring Buracker Construction LLC to perform debris removal and then to rebuild the home. Turns out they didn't properly remove the debris. The contract for rebuild was signed July 6, 2015, and construction commenced. She is not a builder, nor does she have any construction experience whatsoever. She relied upon the capability of the hired contractor, who apparently wasn't a contractor, or the firm, to build the home and the Warren County Building Inspections Office to make sure her home was safe, livable, and that she relied upon the building inspector, that man over there, to do his job. And he didn't. The published and stated goal of the Warren County Building Inspections Department is the enforcement authority for the state of Virginia's Uniform Statewide Building Code and the Erosion and Sediment Control Handbook, having jurisdiction for all of Warren County, including the town of Front Royal, as authorized under Virginia State Statute 36105 and 10.1-562 in conjunction with Chapter 82 and 150 of the Warren County Code. Mr. Beahm and his department are charged with protecting the health, life, and safety of all Warren County residents, and they have failed utterly. By ensuring that buildings and structures are permitted to be constructed according to the Uniform Statewide Building Code, which is part of the Code of Virginia Incorporated, and its recognized standards for health, safety, and energy conservation, water conservation, while meeting the state-mandated erosion and sediment controls. From their website. Construction continued on her home, and there were major issues that the ordinary citizen could see. She reported to Buracker Construction LLC, to DPOR, for DPOR to find Buracker Construction was an unlicensed, or Buracker Construction LLC was an unlicensed entity, and that it never held a contractor's license in the Commonwealth of Virginia. She immediately notified the Warren County Building Department of this fact. Mr. Beahm didn't care. She began to ask repeatedly for a re-inspection of her home. Mr. Beahm didn't care. Her home had been issued a certificate of occupancy on an unfinished and unsafe home. But Mr. Beahm issued it. And one must inquire as to why. He later admitted he missed stuff because he issued subsequent notices of violation. So he either didn't care the first time and was ignorant of these problems, or he read one of the reports prepared and said, okay, yeah, some of these are a problem. And we should have called it the first time, but we didn't. But he didn't catch a lot more. Kristie had to hire, my client had to hire a third-party inspector because she could not depend upon the Warren County building inspector to do his job. She hired a man who y'all heard from last time we were here, who's a Class A contractor in building and in electrical work, and has been in home inspections for 20-some years or so. Mr. Rushton with Able Building Inspections is, I would say, one of the top building inspectors in this area. He found over 125 items that were issues and 60 potential code violations that should have been noticed and of concern to the building official. My client shared her findings with Mr. Beahm, as well as Warren County government officials. You'll see a letter from Doug Stanley where, for a short while, he cared. I suspect when the county began to see possible liability, that caring stopped. After urging for Mr. Stanley to request a re-inspection of her home one more time, she did. Mr. Beahm, Mr. Witten, this lady's boss, and Mr. Robinson came to her home on March 16 and looked at a handful of items and left. Mr. Beahm then issued a notice of violation to Buracker Construction LLC, Martha Buracker. But what's particularly interesting about that, how do you issue a violation to a non-contractor? But Mr. Beahm did. That is why we're here today. Never should have been granted a building permit, but Mr. Beahm did. And she has a, lack of a better characterization, a screwed up home because of it. She feels aggrieved. And she has right to be aggrieved. Warren County and Mr. Beahm have not protected her life, safety, and health as a Warren County resident. In the next minutes, we'll show you how and why there are continuing violations of this home. And ask you to find that the 60 or so code violations previously presented to this board are indeed violations, and at the very least, ask you to re-find that your prior findings were correct. With respect to the suggestion that this board has not authority because of time, and I look forward to exploring this with Mr. Beahm. December 7, Mr. Beahm of 2017, Mr. Beahm delightfully provides legal advice. Additionally, the building inspector's office is required to perform minimum inspections to ensure the work is completed to meet the Virginia Uniform Statewide Building Code. Those inspections were completed and complied with the USBC at the time the inspectors were completed by this office. Inspections were completed by this office. The USBC does provide for re-inspection of work within 2 years that may be found not to have met the USBC. This would apply to work that was permitted. Now the question then becomes, was there a valid permitted? Was any of the work permitted? If it were not permitted, the date would be 2 years from the date of its discovery. Now, I believe the first thing you have to find was any of the work really approved, because there should not have been issued a building permit to the contractor, Buracker Construction LLC, and that's who got the permit. I believe that's the first basis of inquiry. And if you find that, you can't issue a permit to a non-contractor unless it's the property owner, I believe this is general law of the Commonwealth, then everything's a violation. Second instance, the second question, please find that the 60 or so violations that Mr. Rushton set forth in his letter are code violations.
And he did not note them as code violations. He said that they were issues the county needed to relook into. So he did not call those as code violations.
And send the building inspector back out on those issues. This lady is the victim here, not Buracker. Your job's to protect her, not Buracker. Buracker Construction LLC is a legal fiction. It doesn't exist except for as a separate legal entity, and they are not the victim. This lady is the victim, and the law exists to protect her. And I'm willing to bet neither Mr. Hotek, Mr. Hatcher, Mr. Seffel, or Mr. McFadden would want her problems created by Buracker or want to buy her property. And I challenge each of you, if you think Buracker Construction LLC has done their job, she'll be glad to entertain an offer from you for her house. Thank you.
Thank you. Mr. Francis, would you like to address this?
Sure.
We will note our continuing objection to his participation in this proceeding.
But that is noted, and you don't need to say that every time, Mr. Zucker.
I think I need to build a record, sir.
Not to go tit for tat with that, but I will point you again to 119.7. All hearings for the LVBCA shall be open meetings, and the appellant, which is Ms. Atwood, she filed the appeal. The appellant's representative, Mr. Silent, the LaCoadley's representative, is Mr. Beahm and his counsel, and any person whose interests are affected by the building official's decision, which would be my client, because if the building official today decides that my client has notices a violation issued against it, pretty sure their interests are affected, shall be given an opportunity to be heard. And that's due process. It's just an opportunity to be heard. To the extent that we're not allowed to be heard, and as far as that argument goes, I expect that that would be a violation of due process and not anything that we want to get into again, because that was one of the issues at the very first meeting in May 2018 when the Burackers were not allowed to speak. I want to read to you, you all have probably seen it already. It was an email sent June 19th. Quit wasting your breath with these idiots in Warren County. They don't give a explicative about you, Kristie. If any of them did, they would have lifted a finger to help you. They like to see people get or be hurt. It entertains them. Do not think for 1 second any of them give a damn. That was sent shortly after I submitted my briefing to this board. Upon the board's request, that was due on June 14th, the appellants complained that they didn't have notice of that, even though Ms. Atwood was sitting in this room. And when this board noted to all the parties involved that mine was the only filing, that was the response that Ms. Atwood's representative sent to each of you directly. To the extent that there are issues in this case about permitting, I would direct you to Ms. Atwood's appeal. The appeal that she filed in this case years ago. May 18th, she was given an option of May 18th at 10 a.m. Second choice, May 21st, 10 a.m. She filed it on May 3rd. 2018. In that appeal, she said nothing about whether Buracker Construction LLC was permitted. So to the extent that they're asking you today to find that all of the work performed at that house is unpermitted, is again another jurisdictional question. It's not a part of this appeal. It's not before this board, and this board can't consider it. And even if it did, I don't know that the board has the authority to consider that type of thing, because again, the building code says that the board shall have the power to uphold, reverse, modify decisions of the building official regarding code violations. They're asking you to go back in time and decide that a permit was issued invalidly, but that's not before this board. The appeal has two items: a description of the decision being appealed, and as I noted in my brief, she doesn't ever cite a decision, and the relief sought, I want the building department to recognize the errors of their inspectors. She doesn't cite any errors in her appeal. I think what's going on here is that well, there's a volley of different things going on. There's this matter, and there are separate lawsuits or threats of litigation levied at all parties involved. It seems to be more of a shotgun approach to seek a windfall than it is an approach to find justice. If you have any other questions about the jurisdictional issue, I'd be happy to answer them. I will not go into deep detail because you have my briefing before you. If you have any questions about that, I'd be happy to answer them. But for the sake of time and to expedite this process, I won't further elaborate on those things because I feel that I explained it quite clearly in writing, and it's been with this board for about a month now. I will say, to the extent that the appellant's counsel calls her a victim, I don't disparage him for that. He's zealously advocating for his client. But for him to refer to my client as a legal fiction, you'll notice that the Burackers are not here today because Martha Buracker is at UVA fighting cancer. She didn't have any
Your
hair.
Honor, Chairman, I have to object. This is completely
Mr. Saleh, Mr.
immaterial
Saleh, hold on, please.
and
I'll
relevant.
let you say your piece. We're gonna let him say his. Continue.
She's down at UVA fighting cancer. She doesn't have her hair and she couldn't make the trip today. And her husband, being loyal, is down by her side. I'm here on their behalf. There are people involved in all of this, not just Miss Atwood's side, but on my client's side and on the building department's side. There are people trying to do good, honest work and trying to find some sort of justice. It's this board's duty to find that, and I pray that my briefing may help guide your analysis in finding that justice. Thank you all.
Thank you. Mr. Beahm?
Thank you, Mr. Chair. The only item that I would like to bring up at this point in time, and it's the only item that is actually cited as a building code at this point in time, is the fact of issuing a building permit. The building permit, I believe you still have copies of that, the building permit 493-2015. If you duly note, the building permit is issued to Buracker Construction. Thank you.
Thank you.
Buracker Construction did not have a valid business license in Warren County until July of 2018. And that was after Witten made them get a business license.
All right, at this time, Mr. Saleh, if you have any, if you'd like to rebuttal against anything there, we'll hear it this time.
I will.
Briefly.
Legal fictions exist, and the definition legal fiction exists for a reason. It's a construction, legal term of construction. When you form a corporation, it's a legal fiction. It's not a real person. So that's what a legal fiction is. Ask Mr. Hand, he can tell you. To suggest, as counsel for Buracker Construction LLC has said, that a legal fiction exists and his clients aren't here, has nothing to do with the sort. And I'm sorry Ms. Buracker is suffering from cancer. No one wishes that. Cancer and Alzheimer's are two things none of us want. But my client didn't want an albatross of a house. She hired someone to build a quality product, and she got the exact opposite. I'm certain none of you all would want this house. And with respect to what the building inspector just stated, all right, he issued a contractor's building license to someone that wasn't hired to build this house. The building permit, as he says, is issued to Buracker Construction, but it hadn't paid business license fees to operate in the town or county of Warren, town of Front Royal, the county of Warren, didn't have a business license. And then it would become, I believe, when a building contractor comes and signs an application, indicates they're an agent for someone. But Buracker Construction possibly doing business, or Martha Buracker possibly doing business as Buracker Construction, wasn't in contract with her. They didn't have what you would call agency authority. So Mr. Beahm issued a building permit to Buracker Construction, as he just said, but here's the flaw. they didn't have the capacity to get it. And I believe the contractor has to make a representation that they have such authority. The existence of the contract is with Buracker Construction LLC. But as at least 3 of you, I believe, recall from the last hearing, multiple permits were issued, and Buracker Construction LLC was on them, and Mr. Beam's office issued contracts, or licenses, or building permits, etc., to Buracker Construction LLC as well. Thank you.
Thank you. Would you have any vote?
No, Mr. Chairman, I think everything's been said, and for sake of expediting this, I'll indulge you all and take my seat.
Nothing further.
At this time, I'm going to instruct the board to ask the board if they have any questions for any of the parties. All right. Mr. South, do you have any witnesses that you'd like to bring forward?
I do, and I guess as a preliminary matter, Mr. Chairman, if you're going to rule on the request of Buracker Construction, I would ask that you do it now, so we can then proceed. If you're going to decline his invitation or request to have exercise jurisdiction, or are you going to wait till the end of the hearing? Otherwise, it could make the hearing useless and meaningless and a complete waste of everyone's time.
I think, Mr. Silent, I think what I'm going to ask the board, I'm going to step back here for just a minute. The board, we are a body here to determine whether the building officials, the building inspector, the building official has made the right call. It's in my handout. I think it's also in the code. We're here to determine whether the building official did make the right call. I think that's our limits. From previous meetings that we've had in the past, that's the only thing that we can really make a determination on legally. So if that answers your question, Mr. Solid, that is the direction that I'm going.
Very well. I'll call my first witness, Kristie Atwood. Would you like her here, or you don't have a witness? Didn't we have a witness here last time? We didn't. Okay, we said here. Please state your full name and address for the record.
Kristie Atwood, 1255 Pilgrim's Way, Bentonville, Virginia, 22610.
And did you enter into an agreement with Buracker Construction LLC?
Yes, I did.
And is this a copy of that agreement?
Yes, it is.
Mr. Chairman, I ask that this be marked as Atwood 1.
I'll put A1 on the top left side.
And when you entered into that contract, who did you believe you were contracting with?
Buracker Construction LLC.
And why did you believe that?
That's how they represented themselves.
And did they indicate on the contractors, on the front page, that the contractor's information is present and that they have a Class A business license?
Yes.
And they stated to you they had Class A license number 2705048817A. Is that correct?
Yes.
And that it would be in the name of Buracker Construction LLC. Did you depend upon that representation of Buracker Construction LLC in entering into this agreement?
I did.
Why?
Because they were local. I wanted to go local. I thought I could trust them, and they said they were fully licensed and insured.
And did they obtain building permits for you?
They did.
Respectfully, and if the board wishes to hear this line of questioning, I'll defer to the board's judgment. Again, I point out that the only thing that's been appealed here today or his review of possible code violations. With whom she, I mean, I think we're willing to stipulate that we know she contracted with my client, and we can kind of skip all this stuff because the only thing that's been appealed, 1-218, is a review of possible code violations and construction deficiencies. And so that's all that's up here. Maybe it saves some time for you all.
Learned counsel should have read USDC section 108.4, that a prerequisite to obtaining a building permit in accordance with section 51.11111 of the Code of Virginia, any person applying to the building permit shall, or blah, blah, blah. That's a violation of the building code. You have to be eligible to apply for the building permit. And that's contained within USBC 108.4. Therefore, it is germane to the proceeding and is a violation of the building code.
It's not what their appeal requested.
It is. It was in the packet. You only have the front page.
Paula has the rest of the packet. Did you report Martha Buracker and Buracker Construction LLC to the Board of Contractors of Virginia?
I did. After trying to work with them for numerous months to get my house finished and for them to fix big deficits, they would not come back. They were almost at my house weekly, and what they were doing was causing more problems than fixing anything. And so I reported them, and detours who found out they were not properly licensed. And when we were here the last time, we tried to bring this up, but Mr. Whitten said that you guys were not allowed to hear that.
Now, when you were served with a copy of the consent order entered into by Martha Buracker, is that correct?
Yes.
Mr. Chairman, I ask that this be marked as A2. As part of the consent order, what did Ms. Buracker consent to?
I think she consented to pay money and to get remedial education so that she would know how to properly conduct business.
And do you recall the date of that consent order?
I believe it was August of 2017. It's signed in from the consent order.
Pull it up.
It was August 2017.
August
Oh.
8, 2017?
Yeah.
And to the best of your knowledge, did she ever notify you of any changes?
No, and I went to Mr. Beahm and the county and told them they issued a permit to an unlicensed contractor because I have nothing to fall back on D4 where they have that.
Now, hold on. Why was it relevant that the person you were having do the work at your house have a contractor's license?
Because if they're not, then you can't, there's nothing you can do. You have nothing to fall back on.
Are you eligible to receive any monies out of any fund?
I am not.
You recognize this document?
I do.
And what is that?
This is when Mr. Whitten finally made them get a business license in Warren County under Buracker Construction without the LLC, and it's dated July 3rd, 2018.
Mr. Chairman, I ask that this be marked as a Atwood 3. Do you recognize this document?
Yes, this is what my house should have looked like. Similar.
I'm going to ask that this be marked as, I believe, A4. And directing your attention to page 1, the numbers at the bottom right-hand corner. You applied these numbers,
Yes.
correct? And what is that?
That's like the page numbers.
All right, and directing your attention to page 2, what is this plan?
Yes,
And 3?
the plan. Now, the house was supposed to be built in mirrored reverse, and it was also supposed to have the garage stay the same, but have the garage doors face the front instead of it being behind.
Directing your attention to page mark 8. To the best of your knowledge, were these the plans submitted to the county and Mr. Beahm for review?
Yes, they were.
In the top right-hand corner of page 8, or bottom, or whichever way you turn the page.
Bottom right.
In bottom right, if you turn it horizontally, please read for me the name of the contractor and what it says in the bracketed section of page 8.
Buracker Construction LLC.
In the next line,
Class A, licensed and insured.
directing your attention to page 9. What is this?
This is the residential building permit that everyone must fill out, and this is
Now, you said permit. Is this a building permit application or permit? Which?
application.
All right. So, on the application, who is listed as the contractor?
Buracker Construction LLC.
One more time so the camera can hear you loudly.
Buracker Construction LLC.
Now, who signed it at the bottom?
Martha Buracker.
And what notice is provided by the county that she certified?
Nothing. Oh, there's initials above her name.
All right. Please read where it says notice for the record.
Oh, right here. Notice, by signing this building permit application, the undersigned applicant expressly acknowledges that commencing construction before drilling a well yielding adequate supply of potable water, the undersigned applicant assumes the risk of constructing a dwelling house which may not be usable or saleable due to an inability to find water supply for the applicant's dwelling house after construction. I hereby certify that I am the authority to make this foregoing application, that the information given is true and correct, and the construction will conform with the regulations in the building code and zoning ordinance.
And the next line?
Information completed by me by MPM Permit Tech is true and correct.
And who signed it at the bottom?
Martha Buracker.
And at the top of the page where it says state contractor license number, what license number is written there?
2705048817A.
Have you since determined that that license number is not issued to Buracker Construction LLC?
Yes, that is correct.
Directing your attention to page 10. What is this?
This is the permit that is the permit that is issued from the building permit.
Zoning permit?
Yes,
And who is it issued to?
Buracker Construction.
Have you ever been in privity of contract with Buracker Construction?
No.
Yes or no?
No.
Directing your attention to page 11. Is that job site directions?
It is.
Directing your attention to page 12. What is this?
Zoning application.
Okay. Directing your attention to page 13. What is that?
I guess it's the same thing.
Okay. Page 14.
Same.
Okay. Page 15.
Land disturbing permit.
Now, to whom is the contractor license issued?
It would appear to be issued to David Buracker.
To the best of your knowledge, does David Buracker possess a contractor's license?
No,
How do you know that?
I looked it up.
And was this permit issued by the authorized code official of the Warren County Building Department?
Yeah, I guess.
And does it bear a date stamp of July 23, 2015?
Yes, it does.
Have you asked Mr. Beahm or any person in this department how they issued a land disturbing permit for your property to David Buracker when he is neither a contractor or the owner of the property?
Yes.
And what was their response?
It was all okay because it all fell under the same license.
But his name
I'm sorry, I didn't hear that.
He would say that it was like when I would call in here, which was many times and sent many emails because I was like, how did this happen? They said that they issued it to her private contractor's license and not the Buracker construction license. But I was not in contract with her privately.
Page 16. What is this?
That's the permit application, and on all these, under contractor's name, it is always Buracker Construction LLC, so it was not like they were not saying that that was their company.
So, when Martha Buracker applied for the land disturbing permit, which was issued, and which is number 15, the actual applicant was Buracker Construction LLC. Is that correct?
Yes, it is.
And the contractor name or the applicant isn't the same name actually on the permit that was issued,
No.
correct?
Correct.
Page 17, what is that?
Receipt.
Page 18?
This is the certificate of assumed or fictitious name, and this is where finally, after being discovered they didn't have the proper contractor's license and acting like this in Warren County, they were finally forced to get an official business license.
And to the best of your knowledge, did they then file a certificate of fictitious name after they...
They did on July the 3rd of 2018.
Page 19, what is this?
This is when I first started notifying, well, I called the county numerous times, and this was my big first official notice to the Board of Supervisors, the county administrator, David Beahm, regarding about the house and how they did not have the proper licenses and so on and so forth.
What response did you ever receive from Mr. Stanley, Mr. Whitten, or Mr. Beam?
Well, they finally did come out to inspect, but at first they tried to blow me off and was like, oh, well, that's not possible. We give it to her personal license. That's just the way that we do it, and it has been done like that since 2002, which was their company's inception. So every time he gave a permit like this, he was committing a Class 3 misdemeanor.
And what do you mean, why do you think it's against the law to do that?
Because it says you can't do that in the USDC.
Directing your attention to page 22, what is this?
This is where they tried to explain to me how they gave the license to Buracker Construction and not to Buracker Construction LLC, and then the minimum, because at that time I was telling the problems I had with the house, and this was the list of minimum inspections they would do.
And page 23 is just a continuation of that, correct? Mr. Chairman, I believe I provided you all a copy of this.
I haven't. Do y'all each want a copy? I have enough.
Yeah, you bet.
Please give them each a copy.
Let's keep the marked exhibits separate because we need them for our record. So let's just make sure we keep those together.
I have A2, 3 and 4. I
Good.
don't know
That's
what one
all
is.
good.
Oh, I have it.
Are we marking this one?
You can, I mean,
Are we
y'all.
marking this one?
No, I think you've already submitted that, haven't you?
Yes, this is already submitted, I think the
So
last
don't
one.
don't mark that, that's just extra.
Okay.
Yeah, A4 is here.
Directing your attention to this document, you recognize it.
I do.
What is that?
This is an April 12th, 2018 letter from Doug Stanley. This was done after Mr. Beam came out and did the re-inspection of my home, and they did not even look at everything. So I wrote Mr. Stanley a letter, and I asked, well, what about everything else? And Mr. Hotep, remember when you asked about like the civil, like it was like he had listed everything as civil, not code, the paperwork that we had the last time? This was attached to his letter, so I think that's how y'all got that.
I've asked that this be...
I'm sorry, start over on the topic. I'm not
Okay,
following.
so the list where Mr. Bean had went through and put everything as civil matter between owner and contractor, civil matter, everything that he had put in here, he didn't want to say it was a code violation, so he said everything was a civil matter,
Okay.
and that came with Mr. Stanley's letter. So when I emailed you his letter, that came with it.
Okay.
I offer this as our next subsequent exhibit, Mr. Chairman.
Mr. Chairman, could I ask a question at this time?
Please.
So,
I have no objection to asking.
The document that you just showed us,
Uh-huh.
was that part of the original appeal?
It was. It was.
Point of order, no, it was not.
Yes, it was, because I sent the letter, and I did not know this is when I thought Mr. Beahm had sent you the civil, not construction, but it was actually attached to Mr. Stanley's letter, so that's how you ended up with it.
excuse me just a minute. Ms. Secretary, do you have?
The original appeal came in via email. I can go back and I can pull a copy of that to show the documents that were attached. But I've got copies of everything here. That was attached to that original appeal.
Is it in there?
They had it last time. I don't know if they had it.
And that is what you just submitted,
Yes.
and we're marking that as A5, am I
I have
correct?
6.
What is that?
I have 6 in my
I
note.
have five.
Hold on,
We
1,
only have the A4 at this
3,
point.
4, 5. My first item I have as Buracker Construction
Can I have all
1.
that stuff
The
back?
contract.
Give me a
The
second.
contract,
Second is consent order for 4.
right?
Third is business
right here.
license.
Yep.
4 is the plans.
I believe we only have A.
You're right, it's
A1.
5. It's 5.
The reason I asked that question is I recall in the previous hearing, I was sitting over there. I cited the document. Mr. Silik became somewhat upset because you did not have that document that I was citing. Therefore, it's puzzling to me how it was part of the appeal if you didn't have that document at the time of our meeting.
Well, when I emailed the appeal, I thought I was only emailing like this portion of it, but this portion was attached in the same PDF. You understand? Like when Mr. Stanley sent me the PDF, it was all of this.
Right,
So then when I forwarded it to Paula as part of the appeal,
right.
everything came. Because I thought that Mr. Beahm would be bringing that because that was his conclusion.
Can you pull it up on your phone? What do you say? Directing your attention to this document. Can you identify that?
This is the ABLE building inspection. This is my inspection notes.
Please take a moment and look at that. Mr. Chairman, I've asked that Mr. Rushton's report be marked. And that would be 6. And did you have to hire a third-party inspector to come to your home, and why?
I hired him to come to my home, yes, because my house is a disaster.
And at the last hearing, Mr. Rushton was here, correct?
Yes.
And why did you select him?
He was highly qualified and he had done a lot of post-home inspections, and he had been a contractor himself and had a lot of experience.
And he's a licensed electrician as well as Class A contractor, is that correct? And did you request a subsequent letter from Mr. Rushton regarding this matter?
I did.
And what did he set forth in this letter, Mr. Chairman?
What he did was he
There's
picked
3 copies of this.
He picked out the primarily concerned construction deficiencies that could be possible code violations and knocked out the cosmetic aesthetic concerns.
Now, the cosmetic concerns,
Mark that A7, that's all right. These are extra copies of this.
That's a new one. I think we've already done 6. Yes, that's a new one. Those were 6.
in Mr. Rushton's initial report, he had 126 concerns, is that correct?
That is correct.
And in his subsequent report, he identified the items set forth on what's been marked as Exhibit Atwood 7 as concerns that are primary construction deficiencies and possible code violations. Is that correct?
That is correct. And this was done before the county came back out and did their reinspection.
And did the county come out and do a reinspection?
They did.
Mr. Chairman, did the board retain the color copies for each of the members that had previously provided that looked like this? We had provided color copies last time. And I only have one copy of color, which I'll be glad to hand out.
Are you talking about the pictures?
Yes.
Are they labeled with numbers?
Yes, sir.
I have some in, that's from the original, to my knowledge, let me look through my folder here, but to my knowledge, I don't believe I did. Maybe it's possible, hold on just a second.
Is this part of A6?
That's A7.
Oh, okay. And you retain A7?
Okay. Do you want the whole set? from
No,
us?
no, no, I'm fine. I just want to make sure.
That's an extra. Let me see this one.
And here's A5.
I do not, the only copies I have.
I will hand up the only color copy I have and ask that you mark this. I believe it would be number 8 now.
Did any other board members get this, to your knowledge?
I received
It's
full.
sent by email, yes.
Okay.
Yeah, I have it on my
I
iPad.
just think it's about a year ago.
I can make a copy.
That was it. Is this new
No.
No. it was
from the
part-
last, from the original meeting?
Yes,
That's,
sir.
This was all part of the first thing. On my iPad.
Yeah, this was provided 5:15. is
We
what I
marking
wrote.
this as.
I'm
A8.
sorry, Mr. Hurtak, I couldn't hear you.
I had on that, I believe this is a full-size version. You might
Yeah.
confirm that?
So it's, it's the same packet
Yes.
that
But it
was
was-
in the original
Yes,
from the meeting previously that I did not,
participating.
that's, okay.
And in this report or photo compilation, each of the photos that have numbers correspond to the 1 through 125 or 26, showing photographic evidence of either the cosmetic or the alleged code deficiency. Is that correct?
that's correct.
Ask that that be marked as number 8. This is new, is it?
Yeah. Here's the
Please identify these documents for the board.
These were additional pictures that were taken during our rat infestation.
All right, describe for the court your rat, not the court, I apologize. For the board, your rat infestation.
Well, I was down in the basement trying to get stuff ready for Christmas, and like I noticed the smell, and I went to like see what the smell was back like where the hot water heaters and stuff are, and there was like a yellow stain running down the insulation, and I pulled it back, and it was like it had been like a rat nest, and so 3 4-inch pipes that where our outdoor wood furnace was supposed to be were run, and then they were uncovered.
Well, let's talk about the outdoor wood furnace. Did you ever get the outdoor wood furnace?
No,
And was that in the plans for the home?
it was in the contract.
And let's start at the top picture on this. Mr. Chairman, if you could mark this as Atwood 9 or A9, please. What's the first picture?
That,
The bed tape.
okay, that is, I pulled out my electric range, because like I was trying to clean up the rat infestation in my home, and that is the plug for my electric range. It is not secured, it is just out there in the middle of the floor.
It's not attached to the wall? And the next picture?
This is the slab where my outdoor furnace was supposed to go, and those are the pipes that were covered in plastic. When they were covered in plastic, I assumed they were capped. I did not know to look, and now the plastic has kind of disintegrated and now the pipes were open. The next pipe is one that led into the garage. It comes out through the garage floor, and as you can see, there's rat droppings everywhere.
And the next?
These are the pipes in the basement that we capped. We bought those caps and put the caps on, my husband did. And as you see, the insulation has been removed because the insulation was soiled with rat feces and urine. I mean, it was really bad, and we had to have that removed. And then we capped the pipes.
And the following picture?
That following picture is electric wiring that is for our wood burning furnace that was ran into the basement and just left. And that's how it has sit ever since. The rat infestation in the basement not only damaged the insulation, they got in the ductwork. There's holes throughout all the ductwork in the basement, and they've also chewed up the bottom of the doors that lead up from the basement to the house. And then once they got up in the house, they tore up all the bottom of the doors, like trying to get like in and out of places. Christmas Eve, one of the rats ran down my husband's back. It jumped off a wall, and so finally we did get all of them killed.
What concerns do you have regarding siding on your home?
The siding on my home was something that the Burackers talked us into.
What do you mean talked you into?
They said that this was a really good, because with our house, when it burnt, the one thing that really stuck in my mind was how the vinyl siding melted when the fire was. It was just like, and they said that just like amped it up. So I didn't want a vinyl sided home again. And they were like, oh, well, you need to do this smart side siding. It's so wonderful. You know, this is what you need to get to replace it. You know, put that in there. So I said, okay. And then when they had the guys up there to install it, one of the guys was like, yeah, this is the first time I've ever installed this stuff. And they installed it, I guess, like vinyl siding, which you can't do. And so it was installed completely wrong, and it has voided the warranty. The siding is taking on moisture.
Do you recognize the document in front of you?
Yes, this is the LP Smart Side Siding application instructions.
And to the best of your knowledge, the Uniform Building Code allow for the manufacturer to issue instructions for the installation of product.
Yes.
And this will be marked as number 10.
10.
Is this the information you were provided on the siding for your home and the instructions thereof?
Yes, I pulled it off the internet.
Directing your attention to this letter. Do you recognize this letter?
I do.
What is this letter?
This was after my first big email to the county and to the Board of Supervisors. This was David Beam's answer to me.
Ask that this be marked as Atwood number 11. Directing your attention to this document. Do you recognize that?
Yes, this is the first notice of violation that was sent out. What else it contains that?
And what else does it contain?
That contains, that contains the paperwork where Mr. Beahm went through and said that stuff was civil and not construction related.
Mr. Chairman, I ask that that be marked as Atwood 11 or A11.
This is 12.
12, excuse me. Yeah, I did that. What actions are you requesting that this board take on your behalf? On your behalf?
I want them to look at the pictures. I mean, my pictures of my house are self-explanatory, and a lot of them are just I don't know how to build a house. I'll be the first one to tell you, but what I got for my money was not what should have been there, and they were paid well.
Are you asking the board to find that the subsequent issues identified by Mr. Rustin in his second letter be found to be code violations?
I am, as well as the additional pictures that we were gave them.
Additional pictures? We're still dealing with one appeal from 1/2018.
On its
They
merits.
can't ask for anything
merits.
additional.
On its merits.
No, there's no
That is what came from the state technical board.
We're dealing with what was appealed back in 2000, where it's the same appeal. To the extent that anything new has been added to this appeal, it cannot be considered. And I still rest on my jurisdictional argument. But if they've added any new additional alleged code violations to an appeal 1-2018, this board cannot consider them.
It's not additional, it's the same thing that was presented before, but just better pictures.
That's not what you said. You said additional pictures.
They're right, better pictures, additional better pictures of 2 areas. They were notified.
Same violations that
Yeah.
remained in her appeal.
See, but it's still new material. You're adding new material, pictures taken how long after the initial report was written?
Which report?
Okay. You submitted a report in May of
With Mr.
2000.
Rushton's pictures?
Correct.
Yes.
In May of 2018, correct?
Yes.
That's what this appeal is based upon. To the extent that
I'm
you've
agree-
taken
I'm agree.
any new...
And that's fine, I mean, you don't
That's
have to
fine.
consider
You know
them,
what?
they're already listed.
Don't consider the rat infestation and the fact that the stove thing's not attached.
Were the pictures taken after the appeal?
Yes.
They're taken.
Those pictures, the
Then we're not
subsequent.
gonna- we're not gonna
Okay,
allow-
very well, very well. I want the record to be clear that the later discovered issues, which we'll just file a separate appeal for, because they've now been discovered, of the stove thing that was never attached to the wall and the exposed pipes. That's fine. That's fine.
Yeah, 11.
I got 12. Were you trying to give an A12?
I did get an H12.
All right, what is it?
That is the notice of violation.
You've got them all.
Yeah, we got them all. We do have them all. That's what we're doing this.
Gotcha. Thank you. You can have it back.
Still trying to catch up.
The furnace was listed on the initial thing too.
Yeah, I don't have an objection as long as what's before the board is the same thing that was before the board in May of 2018. If there's anything new, now we're looking outside of the original appeal.
Let me ask, Mr. Silent,
Yes.
any of the pictures that were in the packet,
No,
They're all there.
Mr. Rushton took all those pictures.
That's all.
were they in the original?
Yes,
Okay. No addition.
nothing.
The originals are the secondary set of pictures that I gave you, which was number 9. Thank you.
And you said they were color
That's
copies? They
number-
were color copies?
I sent the originals to Paula, so if they were black and white or color, it's whatever y'all got, I don't know.
Well, if A9 constitutes the additional pictures, that exhibit should not be before the board. This is a rehearing. Not
No,
a-
it's not a rehearing.
It is a rehearing.
Same hearing.
It is not a rehearing. Your characterization is not correct. It was sent back for hearing.
It was.
Yeah, for a rehearing. I was at the state technical
No, it
report
was,
too.
in the letter, it was that it would be heard as
It's
news.
just, you two stop. You two stop. What is this document?
That's the trusses, that's the fireplace that was installed incorrectly.
Now, you cited this in your appeal, and what was the problem with the fireplace?
They purchased a heat and glow fireplace, and it was a Vermont castings that was put in, and when we had like the second fire in the fireplace, it completely died.
And
Are we marking this, Mr.
this would,
Silent?
yes, Mr. Chairman, it would be number 13.
I'm gonna mark out your 11.
Yes, please mark out the 11. That was from the prior hearing.
That was nice.
Or we can make this number 9 since y'all are kicking out number 9. Is that what you just said?
No, that's going to be A13, and I don't
Oh,
think the board has ruled on that.
okay.
We do need, I think we do need to replace.
I think this is 13.
Strike A9.
Right, okay, well, here's what we've done. We have before us A9, and I think the discussion has been that we should not consider A9. I think it's good that it's part of our record, but you know, as it is brand new, you all could think about the fact that whether or not that should be part of a rehearing. But as far as not including it as part of our record, I don't think that would be a good idea.
I concur. And I think this would be 13.
Mr. Francis, do you have any objection to that?
No, to the extent that this is an administrative hearing, the rules of evidence are wide open, and this board is educated and understands what they can and cannot consider, that's fine. I just wanted to make the point that we are looking at Appeal 1-2018 or 2018-1, whatever it is. And so the same documents that were part of that appeal in May of 2018 should be the same documents that we're examining now. The only difference between that hearing and this hearing is Mr. Cline is not sitting up there with you, and Mr. Safel, you are here as a new member. That's the only difference in those appeals.
Okay. Well then, Mr. Francis, Mr. Secretary, can you make a note then that A9, we're going to leave it in the packet?
Does the building official object to that?
Does the building official have any objections to that?
And Mr. Silik, I want to give back to you these ones that are marked 11 because this is going to make it impossible for us to keep this thing clear.
These were just provided to you all, but you can just, that's.
If you want to pass them out, that's fine, but
That's
pass some
fine.
stuff
There
that
we
say
go.
11 on them.
No, I agree with you. That was from the last hearing. Now, this is the last part of what you said was wrong with the fireplace. What was wrong with the fireplace?
Buracker Construction Company ordered and paid for heat and glow wood burning fireplace, and when Acme gave them the stove, they actually gave them a Vermont Castings fireplace. Per Mr. Rushton, the chimney did not match the fireplace, and it was kind of like beat together. So that's the first time that the second time that we used it, the doors blew off and all of the fire bricking broke. So we were not even sure if it was supposed to be wood burning or if it was a gas fireplace. And I immediately called the Burackers and they said, oh, well, why are you asking me about a Vermont Castings? And I'm like, well, that's the only book that we got. And they had installed something they didn't even know they installed.
And what occurred with respect to deck railing?
Okay, so with the deck railing, that's a big code violation because it won't hold the, like if somebody big would run against the deck, it's not secured. And Mr. Buracker testified the last time that we were in here that they used the fasten height screws. And so I researched them and I sent pictures to Fasten Height, the company, and it's not, my deck's not installed correctly.
I asked that this be noted as 14. And what else did Mr. Buracker testify to regarding that deck, if you recall?
How that it was done after construction, after permitting. But it wasn't. The only thing that was done after permitting was they moved a, what's that thing called, Victor? A post. Like an anchor
Was it
post.
part of the original permit?
I'm sorry?
Was it part of the original permit?
I don't know.
You don't know if the deck was part of the original?
Yeah, oh yeah, I had it's a porch that goes all the way around the house. And what they had done is they had put the post right in front of the basement door, so you couldn't like walk out the basement door without the post being there. And so then they had to wait until after it passed certificate of occupancy and they sawed it off and then did something else, but Mr. Rushton said that they didn't do it right when they did that.
And cited Mr. Rushton's report, correct?
Yes. The next thing that he has for you is, I know the last time that we were here about the lateral restraints for the roof trusses. The packet does call for lateral restraints. And in Mr. Rushton's report, it says that they don't know how it was inspected in the first place because the house that was built does not match the plans. And he is correct in that because I was supposed to have an unfinished bonus room above my garage. And I only have ceiling trusses. I don't have room trusses.
As that be marked, Mr. Chairman, as number 15.
And you also, and the main reason that I reported the Buracker Construction LLC to D4 was because my house was not what it was supposed to be. And we had no change orders at all written throughout the whole process. So that was when I went to D4, was about the change orders. And they were the ones who found out that she was not properly licensed. And if you look at...
Hold on for a second. How did you find out Buracker LLC was not licensed?
D4 investigator.
And what steps did you take at that time to attempt to resolve the issues with the builder?
Well, I had you as my attorney, and I contacted, well, we had already given them a year, because it was almost a year. Well, no, it was like from September to June is when I found out in June that they did not have a license. And Buracker Construction had been in and out of my home at least 2 and 3 times a week for that whole year. And they were making bigger issues than fixing anything. And then we discovered they were not licensed, and I was told by...
Did you and Ms. Buracker and Mr. Pond, her prior attorney, meet to try to resolve this matter?
You and Ms. Buracker actually met, and we tried to resolve the matter, and that was in November. And they really wouldn't do anything. We had sewer smells trapped in our house. It's just been a nightmare. And then we found out they weren't licensed, and then my attorneys were like, they don't have the proper licenses, you cannot let them back in your home.
We rest.
Mr. Francis, do you have any witnesses you'd like to call or any rebuttals?
Yeah, I don't have any witnesses, Mr. Chairman. I'll just address a couple of the
Parliamentary point of order, Mr. Chairman. I believe if he wishes to make argument, that's different. If he wishes to testify, well, I believe we're in the evidentiary phrase. And that's what we're doing here, taking of evidence for the board to make its decision, not necessarily argument at this time.
Mr. Francis, this time, let's proceed with...
If Mr. Salik has more witnesses, I'd gladly defer to him.
Would you have any cross-examination? Yes. Did you have any cross-examination from Ms. Atwood or her attorney?
Or the building?
I can ask her a couple questions.
Okay.
You mentioned those deck posts. Isn't it true that you asked them to move that deck post?
The deck post was in the way of the door. So yeah, we were like, we can't open the door with the deck post there.
So to the extent that you asked them to move after it was permitted?
I did not ask them to remove after it was permitted. I asked them to move in the building process, and they would not.
But then you asked them to move it?
Yeah, because it's
And
in the
they
way of the
did.
door, because it blocks an egress.
Okay, that's a design.
It was not
But you asked
designed like
them, you asked them to move it, correct?
that. I wanted them to move it under what
I'm
was,
asking you a yes or no question here.
I'm not going to answer it.
Very well.
Think about that. Hold on.
Hang on a minute. Ms. Salik.
Yes,
Let me
I asked him to move a post that was in the way of opening my basement door. Yes, I did. Multiple times before we got the certificate of occupancy.
Mrs. Atwood, can I ask you a question in regards to that? Was the post moved after the final inspection or prior to it?
It was moved after the final inspection, and I did not ask him to do it after. I asked him before.
And after you asked them to move it, is that not one of the code violations you asked this board to find?
No, the code violation is how they rebuilt it. I didn't ask him to violate a code. I just wanted a post moved because it should never been put there in the first place.
Okay. With regard to that furnace,
Which furnace?
well, apparently the furnace that was never installed.
You mean the outdoor wood furnace? There's 2.
Correct, the outdoor wood furnace. Is that related to any code violation?
Yes, it is.
The fact that they did not install a wood furnace is a code violation.
Actually, it is because they had already ran all the electric and the conduit into the house, which breaks the fire barrier, so it is a code violation.
Just not installing the furnace is a code violation.
Yeah, because they don't block the fire barrier and leave the pipes wide open.
Yes, but the absence of the furnace itself.
Yes, it is, because if not, you have open pipes to the outside where rats and snakes and whatever else can come in your house.
So I think you're thinking of uncapped pipes being.
No, I'm thinking of a not installed furnace.
Okay.
And that was part of the contract?
Yes, sir, it was contract addendum A with a furnace.
Right. Breach of contract items aren't really
I'm
something
not saying
that
breach
this
of
board-
contract.
They're not really something that this board considers, though, are
I
they?
didn't say breach of contract. I said I don't have a furnace.
Well,
That breaks the fire barrier.
I'm asking you again, though. You said it was a contract item, correct?
Mr. Chairman, if I may, I know we don't do the normal rules, but this question's been asked and answered at least 4 times, and she has indicated to council at least 4 times that she contends the code violation is created by the breach of the fire barrier and/or allowing ingress and egress into the structure because the contractor placed pipes and wiring from the outside to the inside and did not cap them since he did not put into place the required furnace pursuant to the contract. Now, council wants to characterize this as a contract action, but failure to connect the wiring and the pipes to something, be it caps or the furnace, creates the code violation.
All I was asking is whether she characterized it as a contract issue. Only point I'm trying to make is this board doesn't consider the contract. It considers the Virginia Uniform Statewide Building Code. And well, I'll save it for argument. Those were a couple clarifying points I wanted to make. I don't have any other questions for her. I think it's all been addressed a couple times already, so I'll rest.
Thank you. Mr. Beahm, would you like to call on witnesses or cross-examine?
No, sir. No.
Do we have any testimony of any other parties? I'll take it as a no.
I have, well, whether you want to call it testimony or argument, I have contentions from my client that addressed some of the more specific building code violations.
I was going to start first.
That's fine.
Then Ms. South.
Sure.
Well, I guess I need to make a point of inquiry of the chairman and/or counsel for the bar, who I believe may be quasi-parliamentarian. Are we allowed to argue in closing that which was not presented in evidence for the board? Because I believe that's what Mr. Francis is suggesting.
I don't know what Mr. Francis is suggesting, and we'll see what his argument is, but generally speaking, you know the answer to that, and no, you are not to do that. My understanding from our rules is the procedure is going to be, you're going to go, then everybody else is going to go, and then you get the final rebuttal, Mr. Simon.
Very well. Thank you. So we are in closing statements.
Well, if that's the way you want to go, I can submit to you a few documents from my client.
Were they during the first hearing?
Well, they were not allowed to speak at the first hearing.
They didn't ask.
That's not true.
They did not ask to speak in the open forum. And if they did it in silence, then that's a break of the sunshine law.
Are you asking the board to reopen the evidence so that you can present something new?
It's a couple of their rebuttals to code violations. Admittedly, these were code violations that were issued in June, not in March, which the Burackers appealed later on.
Which would not have been part of the initial hearing.
Well, again, they weren't allowed to present at the initial hearing. So if that's,
What's good for Goose is good for
Does
the
does this concern the violations from the alleged in the initial hearing?
after the first hearing, the board ordered that Mr. Beahm issue 12 violations in a notice of violation. So, to kind of break this down a little bit.
Well, let's stay with the proper procedure here. Are you trying to present evidence at this time?
The only evidence I have is the Burackers' rebuttal of about 10 of those alleged violations. That's all it is.
Okay, well, so you had previously rested, so, I mean, the board...
I rested from any kind of cross-examination of...
Well, maybe misunderstood or maybe
Okay.
didn't, but either way, you asking now to present evidence.
Sure, I'll submit these documents to the board that rebut.
All right.
My pictures weren't allowed. I don't think
Hear
they should
that,
be
then
allowed.
they certainly can.
If we are considering the May meeting, not the June, is what the gentleman's referring to, is then this board did cite things. Mr. Beahm spoke to those. We had another hearing that was from the Burackers
That's correct.
appeal. Then these statements were presented at that meeting.
That's correct.
So it was,
But
how that relates to this hearing, I believe we are going back to the May hearing prior to any
Correct.
action that this board took or anything else.
Right, so the fact that they didn't say anything then, you know, the point is that we need to be talking about her appeal and, you know, any violations that came out of that. And is that what you want to speak to?
the violations that this board issued in June, or directed the building official to issue in June, came from her May appeal last year.
Okay.
Right, and
And-
we withdrew some of those, didn't we?
Correct. And now, of course, they've all been re-alleged because we've gone back in time, essentially. And so all I have are rebuttal items that were presented in that June meeting, in that June appeal, because, they weren't allowed to speak at the May appeal. It's the whole reason they appealed in the first place. They weren't allowed to speak in May. If this board is concerned about protecting procedure and avoiding another shotgun blast, I understand. I can rest with my argument, and I'm happy to do that because I'm confident in it. And I believe, again, this board will see my argument on the jurisdictional matter, and I'm confident that this board will not find that any code violations exist. So if you're concerned about accepting evidence at this time that was not presented in May, okay, the only thing I'll say is they weren't allowed to present evidence in May, so this board would have never seen it anyways. It took my client appealing a decision from this board to be able to get evidence to this board. If that's the way we have to do it again, we're prepared to do that.
Right, well, if you want to submit evidence, first of all, you had, maybe I misunderstood you, but
I probably spoke.
I thought
unclear.
you would rest. So, I mean, maybe you could ask that the board reopen the evidence so that you could present whatever you want to present. That'd probably be procedurally the best thing to do.
Sure, I'm happy to do that. If the board wants to consider.
All right, so what, are the board members agreeable to that? Allowing him to present evidence?
No, I'm not agreeable. I'm not sure he needs to. As I recall, we had the first meeting and we came up with a bunch of things which we directed Mr. Beahm to issue a violation. And Mr. Beahm said, I will issue a violation on everything that's in the code, but there's some stuff, I don't see it in the code. And then so we couldn't see it in the code either, and we withdrew them. So I don't think we have to go back to that again. I mean, unless somebody can show that those things we withdrew were actually in the code, what are we going to do?
The board has already ruled that they are not.
Yeah. Doesn't seem like going back over those is...
And I would raise one additional objection. If counsel wants to make himself a witness and subject to cross-examination, I'm okay with that. But if I can't cross-examine it, as counsel so eloquently stated in his opening statement, the right to due process, that's a problem. So if he wishes to make himself a witness and subject to cross-examination, he, I think, can present evidence, but we present evidence through witnesses, not through counsel. Counsel is making himself a material witness, and if I can cross-examine him to, as he said, assure due process, I'm okay with it. But otherwise, I have to object to him entering any argument as evidence.
Were you planning on entering any of the documents through any witnesses here today?
No. No. And if the board is uncomfortable receiving any of those documents because of that, I understand, and I'll sit down. So, that's fine.
I'm gonna make a motion that the board take a vote on this real quick. And I wasn't present at that May meeting, so.
I do not have any witnesses, so we'll make that clear. There are no
So is your
witnesses
motion to accept his information or not?
I'm making a motion to ask the board members whether they feel comfortable allowing this or not.
If I'll withdraw any contention that I have evidence to submit, if that makes the board's life easier.
Okay.
You have my brief, and I can rest on my argument.
Mr. Beahm, do you have any questions for, or rebuttal for us, or any of the witnesses?
No.
Okay.
So I can get my closing?
Yes.
Gentlemen, first, counsel foreshadowed, Mr. Francis foreshadowed something that didn't come into evidence. He read to you an email that I sent. He didn't introduce that into evidence. And I hope I'm wrong. I hope my email to whoever it was on the list that you don't give a crap about her is an error. Because as I started today, I said she's the victim. She still is. Exhibit 1 clearly demonstrated who she thought she was dealing with. There was no ambiguity. She thought she was contracting with Buracker Construction LLC, and indeed, Buracker Construction LLC went to that man's office and applied for a building license, applied for a land disturbing permit, presumptively an electrical permit, but didn't have the legal capacity to do so. And I'm quite certain Mr. Hotek, Mr. Hatcher, Mr. Savell, and you, Mr. McFadden, if you contracted with someone who held out a sheet of paper and they gave you a contractor's license number and you found out that was false and that it was a lie, you would not be happy. You wouldn't be happy at all. And you gave that contractor permission to request and permits and to act in your name. You later found out that the electrician you hired to come fix something at your house, or the plumber or contractor to fix your septic system or install one at your building, and it was a lie and you were on the hook for it, not one of you would be happy. And then, if you found out that this man issued a building permit to a company that wasn't the applicant, you would be equally disturbed. As a taxpayer of this county, and my family's been here as long as it's been here. Mr. LaHue was my 7th great grandfather. If you were a taxpayer here, which each of you are, and you found out that your civic employees, the people that are paid by you to enforce the law, to obey the law, and to make sure the homes in this county are safe, issues building permits to those to whom they should not be issued, you should be enraged. Not just upset, enraged. That man is entrusted by the citizens of this county to protect us. He didn't in this case. And in any other case, he gave Buracker Construction LLC a building permit, electrical permit, or any other permit. How convenient is it for Martha Buracker or David Buracker to have such a cozy relationship with the building inspector's office that they can go into the building inspector's office and know that the building inspector's office is going to issue them a building permit even though the construction company making application doesn't have the requisite licenses. We hear about malfeasance in this county. We hear about, in fact, since we were last here, crap has hit the fan in this county. A lot of crap has hit the fan in this county. You have to wonder what level of collusion, we hear about Russian collusion, but what level of collusion is rampant in that building inspector's office down here at the end of this hall? That Mr. Beahm and his staff just willy-nilly ignore the name of the applicant and issue a contractor's permit to whoever walks in. Apparently, Dave Buracker can go in and get a land disturbing permit issued in his name, even though they know it's really should be under his wife's name, but they put his name on it, and he doesn't have a right to do that. It just boggles my mind that any reasonable person thinks that's acceptable conduct. Exhibit 2. Ms. Buracker and trading as Buracker Construction is found to have and consented to a finding of misconduct. Exhibit 3. My client discovers through her diligence that Buracker Construction didn't even have a business license in this county. Mr. Hotek has a business license. Mr. Hatcher, when he practiced and worked, had business licenses. I assume you do, Mr. Safel. Burackers didn't have one until 2018. So, combined with the fact that Buracker Construction LLC didn't have a contractor's license, they were obtaining permits in the name of Buracker Construction, which wasn't licensed or paid the fee to do business in Warren County. Packet 4. Packet 4 has a lot of interesting things in it. A whole lot. And they're things that should just cause you heartburn. This is that evidence that starts with the juicy one, page 9. Residential building permit application. Contractor name. Buracker Construction LLC. State contractor's number. Never has been associated with Buracker Construction LLC. Someone in that office should have a duty of due diligence that when they see this number right here, 270-504-8817A, to look it up on DPOR to see if it's a valid number. It's either a keystroke or a phone call away from Richmond to determine if it's a valid contractor's number. Now, I bet if that lady right there, or that gentleman in orange, or the gentleman in gray, or the gentleman in black, walked into that man's office and handed up a building permit application, and the office person didn't know them, they would look up the contractor's number. But apparently, in this case, they didn't, and they never did until my client fell victim to them. Number 10 of that packet demonstrates the incompetency of the office in issuing something that never should have been issued. If Mr. Beahm and his office can't get the mere issuing of a building permit correct, to a licensed contractor correct, it necessarily follows that we must question all of the determinations as to whether something meets code. And that's why my client had to hire a third-party independent inspector. And I bet some of you know Mr. Rushton. He's been around a long time in this community. He's a Class A contractor, unlike Buracker Construction. He's an electrician, unlike Buracker Construction LLC. Excuse me, as previously said, Buracker Construction is not a contractor. They have a contractor's license attached to it. But Mr. Rushton is a contractor, unlike Buracker Construction LLC, which still doesn't have a contractor's license. It follows that he understands the permitting process, Mr. Rushton, because he testified to it last time. Here we have exhibit number 12. We have a Warren County zoning application. Now here, Ms. Buracker signs it in her personal capacity and says it's going to be built on the same spot as the last house, and then signs off on the page 14 using the prior drawing, and then we have the land disturbing permit. And unfortunately, page 16 is in front of page 15 is in front of page 16. Page 16 we have the land disturbing permit application. Once again, Buracker Construction LLC is the applicant. The state contractor's license is attached to Martha Buracker. And how do I put this? Mr. Beahm didn't take the stand to testify. He offered no evidence in rebuttal. He offered zero explanation for his office's misconduct. He offered no explanation whatsoever why a man who doesn't have a business license is issued a land disturbing permit. And I'm willing to bet, Mr. Safel, that if you began disturbing land and building something without a land disturbance permit, you would be in trouble. It would cause problems. Bank wouldn't like it, county wouldn't like it. You would think the Lord Fairfax Soil and Conservation District wouldn't like it. But again, there's some sort of collusion going on because that man's office issued such. Why? He didn't give you any explanation. Exhibit 5. Mr. Stanley's letter and notice of violations, and Mr. Beam's saying everything's a civil matter. The evidence, I believe, is uncontroverted with respect to issuance, and then the problems of the set forth in Mr. Rushton's report, which was 6, and Exhibit 7 of the narrowing of the removal of the cosmetic issues of all of these numbers. The respondent, or Mr. Beahm, offered no rebuttal to any of this. I would suggest he has conceded that Mr. Rushton's
Objection to just because someone doesn't testify doesn't mean you make a finding of guilt. It doesn't mean it's conceded. I think that's a legal conclusion and a jump there. I don't mean to interrupt your closing, but...
Well, I'll respond directly to counsel. If someone does not offer evidence to contradict the evidence of my client, they have ceded it. They have ceded it. They haven't denied it. and they offer no evidence contra to it. Therefore, logic dictates they have ceded the issue.
Or we make a motion to strike.
Can I ask you a question? Mr. Selig, can I ask you a question?
Yes.
Not this one.
So-
Let's one questions for you.
On,
You will have a chance to do
on Exhibit 7, the narrowing, which we concede, the rest of the report, Mr. Rushton says, is cosmetic. These are the issues that are essential to my client's well-being and the safety of her home, and that she contends are code violations. And we ask that you find such as code violations. All those matters set forth on A7. If the defendant, not the defendant, the respondent, whatever you want to call Mr. Beahm,
Helen.
or for that matter, the Buracker Construction LLC, if they wanted to dispute that, they had that right. We've heard no evidence contra. Paragraph or subject A8. I wish I had the opportunity to make enough color copies for everyone so you could see it. But hopefully most of you have the big thick packet. And Paula, did you print them in color form?
Originally, yes.
And if you want the color copies, I will email them to you promptly and immediately. Can you do that right now? Do it right now. So you have the color copies for your, oh, you got it. They are so interesting to see. And as you go through it, think of yourself as the homeowner. Would you be pleased with the work product presented? I assure you, you would not. You would not want that quality of work in your home. I'll skip over Exhibit A9. With regard to 10, Mr. Beahm presented nothing to dispute that the siding was installed incorrectly as set forth in the Rushton report. The Burackers, again, set forth nothing to contradict that finding or suggestion by Mr. Rushton and the analysis on it. I want you to think about your house. I know your house. You live in a beautiful house, Mr. Hatcher. I've driven by it many times when the Hers were out your way. But if you had the entire exterior cladding on your house declared void of warranty because your contractor installed it incorrectly, quite confident none of you would be happy. Mr. Beam's letter A11, fortunately, provides a great little paragraph that's highlighted for you that says time frame, and my client kept finding things. 12, and the rest of them, I think, speak for themselves. The lady sitting to your left has been harmed. Her family is at risk. She's already watched her house burn up once and lose nearly everything. Built a new house, only to find that she's been hurt again, and that Mr. Beahm allowed a contractor, oh, I forgot, not a contractor, that he issued a building permit to build her a new house, which is terrible. Mr. Beahm neglected his duties, and through friendship, favoritism, or whatever else allowed a situation to occur that never should have occurred. And again, he's provided no explanation as to why he allowed it to occur. He doesn't dispute through testimony here today any of my client's contentions. We ask that you find stuff set forth in Mr. Rushton's separate letter to be violations of the building code, and to grant the violations that she seeks against the builder, and that they be held accountable. Thank you.
Just address a couple issues real quick, gentlemen. You know, it's funny, I made the objection about the permitting issue, that it being irrelevant, and they spent maybe 20 minutes talking about the permitting issue as if it's something for this board to consider, and then spent another 5 to 10 minutes in closing talking about the permitting issue, and then we finally get back to the relief they want, and it's those 60 violations, which happens to be the only thing that they asked this board to review in the application for an appeal. So again, I maintain again that any consideration about that permitting stuff and collusion. You gentlemen have worked in this county for a long time. I know a lot of you know Mr. Beahm personally. He's accusing the man of colluding with the Burackers, who are also respected in this community, to build a woman a house. I mean, what? Alleging that this is some nefarious operation to ruin this woman's life. He's also called all of you idiots.
Oh, no,
Objection.
that was not to them.
We're hearing closing statements at this point.
Quit wasting your breath with these idiots in Warren County. I didn't need to put it in evidence. He sent it to the county. He sent it, I can read to you who sent it.
Should try that in the evidentiary proceeding portion, but you didn't. Objection. Move to strike the remarks.
Anyways, he said what he said, and now he's asking you to believe that there's this conspiracy in the Warren County Building Department about these permits. But then the relief they seek has nothing to do with permits. It has to do with 60 alleged code violations that were found by some person who's not a building official. And so then that brings me to the next point. And I laid it all out in the brief that I sent you upon this board's request. The Uniform Building Code is very specific about who is allowed and who is not allowed to find code violations. There's one person who's allowed to find those, and that's the building official. It's the only one who's allowed to make that determination. That's the law. Just one person. Now, the building code says that if that person wants to designate that responsibility to other people, like third-party inspectors, the building official has that discretion. In this case, I don't believe that the building official has designated that authority. It rests with him. It rests with him, and he also enjoys sovereign immunity for that authority.
No, he does not.
Because it's a governmental action. It's a governmental action which he operates with wide discretion. Enjoys sovereign immunity for his decisions in that position.
No, that's gross negligence.
Right.
And to my knowledge, he has not designated that authority to anybody, including Mr. Rushton. So Mr. Rushton has no authority to come into somebody's house and to tell them that they have code violations. Now, maybe his experience as a building inspector leads him to find things that may be possible code violations, but that's exactly what he called them in his report. They're possible code violations. They're potential code violations. He has no authority to come in and tell this board that is a code violation. The only person who has that authority is Mr. Beahm, and he's spoken. He's spoken a number of times this board's authority lies in the very narrow parameters of accepting, reversing, or modifying the decisions made by the building code official. That's all this board does. This board doesn't take a report anew and look at it and go, oh yeah, that is a code violation, or that, that right there, and now Mr. Building Official, you have to find that that's a code violation. This board doesn't have that discretion. It can only take what the building official presents before it and say, you got that right, that wrong, or you need to tweak that. That's all the authority this board has. And I tried to lay that out in pretty plain language in the brief. If the board had the authority that the appellant contends it has, any one of you gentlemen would be able to walk into somebody's house, identify code violations, and then go down and tell him that he must order them. I don't think that's the way it works. I really don't. I think the code is pretty clear. And so to the extent that there are 60 potential violations that are sitting before you, if the building official has decided that those aren't code violations and he hasn't issued any NOVs, there's nothing for this board to consider. Because you don't have a decision of the building official before you.
Not making a decision is a decision.
You don't have anything before you from Mr. Beahm. You don't have anything to reverse or to modify or to accept. And to the extent they've got a problem that he hasn't found violations, that's an issue with him, not with this board, and then he goes and enjoys sovereign immunity. And then we have the question of timeliness. Counsel had mentioned that, that the appellant has a 2-year window for reinspection, but that's a totally different situation than appeals to the local board. Asking the building department for a reinspection is not the same thing as asking for an appeal to this board. Code is clear that an applicant shall submit a written request for appeal to the local board within 30 calendar days of receipt of a decision being appealed. Well, certificate of occupancy was issued on July 19th, 2016, 2 years before she applied for a May 16th, 2018 appeal. So, no appeal was made to this board on the certificate of occupancy within 30 days. If she contends further that the March 30th NOV that was issued by Mr. Beahm in response to her request to reinspect, now that reinspection occurred within 2 years of certificate of occupancy, so the request for reinspection is okay. He did that. Then the March 30 NOV that he issued, maybe that was an appealable decision, but she didn't file her application for appeal until May 3rd, outside 30 days. And so again, we have two timeliness issues on top of the jurisdictional issue. And so altogether, I would contend that, one, I would agree with this board's decision to go ahead and hear all the evidence, give every party their time in the sun and the opportunity to speak and present evidence and so forth. But before you is no decision of the building official. Nothing. It's a report by an independent third-party inspector who has no authority in this county to find that code violations exist. It's just his opinion. The only one who has the authority to take those violations, issue an NOV on them, is Mr. Beahm. He didn't do it. And that decision to act or not act was within his discretion. And then you have two timeliness issues. She's appealing. She wants to talk about permitting issues 2 years after the fact. But as far as she's appealing any decision of the building official, 30 days expired long before she ever filed Appeal 1-2018. So again, if you have any questions for me, I'd be happy to answer them. Otherwise, I rest on the argument in the brief I submitted before June 14th.
But, Mr. Beahm,
It was indicated that I ceded responsibility. I have not ceded anything. There are 4 members sitting in front of me of the board. 3 of you have heard all the facts previously. There's no need to try to explain those facts any further. You've made a decision. You reversed a decision.
I'm going to object.
we're in closing argument.
I understand that. He is now asking that prior proceedings be incorporated without the introduction of evidence in argument. That is improper.
I don't know what he's asking for, but I know he's trying to get his argument.
Counsel, he just said 3 of the 4 heard all of the evidence last time and made a decision, so on and so forth. This is a new hearing de novo, as I understand it. And therefore, his asking that the board, or at least 3 of the 4 who are here, to incorporate evidence from the prior hearing is improper.
Your words. He doesn't use the words incorporate evidence from the
Well
prior
then,
hearing.
very well.
Did you state the fact?
Continue with me.
Thank you. There's 1 new member on this board. You all will decide what you decide today. If you decide that there are the original 12 that were decided previously, that I've written a notice of violation on, so be it. Part of those have been withdrawn by me because the notice of violation.
This is an
Again, objection. None of this was evidence.
Go ahead, Mr. Beahm.
Thank you. Whatever your decision is today, it won't stay here. It will be going to the state. I can guarantee that at one point or another. You may hear additional arguments depending on what you decide today. There's no need for me to waste any more of your time at this point in time to argue anything. Thank you.
Thank you.
And our rules provide that the applicant gets final rebuttal and then we can do questions if there are.
Mr. Silent?
Thank you, Mr. Chairman. Title 51.1-1111, Code of Virginia. Prerequisites to obtaining business license, building permit, etc. Any person applying to the building inspector of any other authority of a county, city, or town in this Commonwealth, charged with the duty of issuing building or other permits for the construction of any building, highway, sewer, or structure, or any removal, grading, or improvement, shall furnish prior to the issuance of the permit either 1, satisfactory proof to such inspector or authority that he is duly licensed or certified under the terms of this chapter to carry out or superintend the same, or 2, file a written statement supported by an affidavit that he is not subject to licensure or certification as a contractor or subcontractor pursuant to this chapter. The applicant shall also furnish satisfactory proof that the taxes or license fees required by the county, city, town have been so paid so as to be qualified to bid upon or contract for the work for which the permit has been applied. It shall be unlawful for the building inspector, that man, or other authority to issue or allow the issuance of such permits unless the applicant has furnished his license or certificate number issued pursuant to this chapter or evidence of being exempt from the provisions of this chapter. The building inspector or such other authority violating the terms of this section shall be guilty of a Class 3 misdemeanor. All of the alleged code violations must be code violations because the permit never should have been issued. Must be. Here we are. That man had done his job properly. We wouldn't be having this conversation. Counsel's argument that there's no decision, reversal, or action, it's the approval of these things that's the problem. When I heard it, Mr. Francis argue, I wrote down action by inaction is what's being appealed. The finding that these things are satisfactory when they can't be. Because there couldn't have been building permit issued to the contracting on the application. It's a materially false statement to obtain a building permit. Let that sink in for a second. If you don't have a building permit, how? A legitimate building permit, because at the core of this entire matter is there was fraud to obtain the building permit. Let that sink in. And if it's not properly permitted, obtained permit, how can it be approved and actionable work? Buracker Construction LLC was the applicant. They put down on the form a license number not associated with that entity to obtain the permit. That's wrong. And therefore, all of the alleged violations have to be violations because they never should have been approved. Because it wasn't a properly obtained permit. Thank you.
Thank you. At this time, it is the board's time for questions.
Chairman, could we do a 5-minute recess?
We can.
That's a good idea.
Yeah.